All right, everybody. Welcome to the Creative Finance Collective. We are here to talk about creative financing and answer any questions that you have. We'll take questions for as long as you have them. And so make sure to bring the questions. Once we don't get any more questions, we pack it up and we move out. Today it's just going to be Sean and I. Maybe one other person may join on. We'll see how that goes. But again, if you have any questions, make sure to post them in the chat. Also, you'll notice at the top corner of the screen there is a barcode. So if you're watching the collective on Facebook or X, you can scan that barcode and that'll take you to the NREM YouTube channel. That's really the best place to interact with us. So go to that channel, subscribe, like the channel. We'd appreciate that. It would help us out a ton. All right, we're going to get into this. Sean, we have one question to start it out. We'll see if we get more along the way here. Can you wholesale a property you purchase subto? So, integrating two different real estate investment type strategies, maybe a wholesaler here, maybe a subto that wants to do wholesaling. Can you do both? And what do you need to be thinking about when doing both?
Well, you can't wholesale if you've purchased it already. If you've purchased it already, then you're either going to, well, let me back up. Yes and no. So the question is, when I think of wholesaling, I think of you have an existing purchase contract, you haven't closed escrow, and then you're going to assign it. You can do that with the subject to transaction. The key, and man, this has been missing. I don't see this, and people are in my view, investors are doing it wrong. Generally, the end buyer's an investor, so it's, they kind of know what's going on. But your assignment on assignment of a subject to purchase contract. So if you're going to wholesale a subject to purchase contract prior to closing, you need to put in your assignment the legally required disclosures for the end buyer. So the end buyer needs to understand fully, and you need to know that the end buyer understands it's a subject to. The end buyer needs to understand what the risks are of buying a property subject to, the whole thing, and get them to initial and sign and all of that. So yes, you can assign a subject to purchase contract. Now, let's say you've closed escrow. Can you then assign? It depends on the language of your documents. If your note and deed of trust contain the language that my notes and deed of trust will contain, then you can assign those. So what you would do is you would basically convey the property to the new buyer by warranty deed for a flat fee, some amount. And then you would assign to them the wrap promissory note and the wrap deed of trust. And they would then assume your obligations under the wrap note and wrap deed of trust. So the wrap note and deed of trust need to have assignment and assumption language that says, yes, this is assignable and assumable by a subsequent owner of the property. And if it has that magic, without the seller, without the holder, without the beneficiary's consent, and if you have that magic language, then yes, you can assign it. The other thing you can do is you can close on if you're in a state that allows for it. I know Texas has these issues that you can't, but in Arizona, Wisconsin, we can. In Wisconsin, we call them land contracts. In Arizona, we call them agreement for sales. So in that case, if those documents have that magic assignment language and say, yeah, they're assignable and assumable, then for a flat fee, you can basically assign it to a new purchaser. And when you assign it, you would record a notice of assignment of agreement for sale. So you put the world on notice. You've just assigned as the purchaser your interest in the property that you had under the agreement for sale. And you also provide to the servicer, presumably, hopefully you've put a servicer in place. You provide to the servicer a warranty deed from you as the original purchaser to the new purchaser, so that when that new purchaser performs 2 warranty deeds are going to be recorded, the seller to the original purchaser, and then from the original purchaser to the end purchaser, so that title is clean that way. So you can actually post-closing assign, I don't know that we call it wholesaling, but you can assign your subject to transaction post-closing and your land contract or agreement for sale post-closing if you have the right language, and that's critical.
Yeah. All right. A lot to that. So if you're just now joining us, this is the Creative Finance Collective. So we're talking about creative financing, but we're here to really answer any questions that you have, and we'll only be here as long as we're getting questions. So make sure, if you're watching, to post a question, any question that you have relating to real estate and creative finance. We'll do what we can to get to it. Also, we have a barcode here at the top of the screen. That's meant to take you, if you're on Facebook or on Twitter, X, anything other than YouTube. That's our YouTube channel, and that you scan that barcode, it'll take you to the YouTube channel. Like and subscribe. We'd appreciate it. We have another question, subto question here. Most of the time when we're talking about a subject to transactions, we're talking about buying the property subject to the existing mortgage on the property, but it doesn't have to be just the existing mortgage on the property. So this question, Sean, is, are there any liens that you would never want to take subject to? You could, in theory, right, take subject to anything that's out there. And if you're not doing some sort of, if you're not careful, there might be more out there than just the mortgage, or a single mortgage that the seller has. Are there any liens that, and keep in mind, any lien could be resolved or settled, but is there a lien out there that, in your experience, investors are staying away from all the time, or that you wouldn't want to ever deal with?
So assuming the property is not homestead, I would not want to mess with judgment liens. Because honestly, Andy, if I were a judgment creditor, and I saw that property had been transferred, even if there was little equity, I'd probably be all over it and try to foreclose, because I would hope to basically strong arm the end buyer to pay me because they don't want to lose the property. And so I'd be all over that. So I don't like judgment liens that actually attach, assuming it's not homestead, actually attach to the real estate. I don't like judgment liens at all. Those would probably be the big ones where I think they would get aggressive. I don't like any liens, honestly, liens that are within 6 months of the purchase. A lot of federally insured loans require certification by the borrower as to the fact that they're going to reside in the property, and I don't want to be put in a position that I in any way conspired to misrepresent, to mislead, to misstate this information to the lender, that I in any way conspired with the seller / borrower to have certain things happen based upon certain representations, knowing that they weren't going to perform under the contract. So that's right. Another one where I would be looking at the dates and saying, okay, where am I? FHA subto, it's a high risk transaction. There's certain things with the FHA, certain ways you may want to structure it, but nevertheless, with the FHA, the borrower represents that they're going to be there for a year after the closing of the loan. So I would definitely want to, I wouldn't even touch those, within that 1 year period.
Yeah. So follow up, I think this kind of flows into this, but if you're buying property subject to, that doesn't extinguish the need to do some title due diligence, right? Hey, I'm going into this, I'm buying sub 2, so I don't really need to worry about what's out there. I'm buying it sub 2. Well, yeah, you probably do need to worry about what's out there, given what could be out there. So are you, you're still on these deals, the recommendation would still be to do some title work on the property, right? During the escrow
Yeah, in
period?
fact, yeah, I would as much as if it is doable, I would, acquire property subject to with a title policy,
Yeah.
so that I know what's out there. I know what I'm dealing with, and I've seen it where the policy has a bunch of stuff out there. For example, here's one in Arizona. I don't know outside of Arizona because it's very specific. In Arizona, if the property's on a septic, the Arizona law provides you can't transfer it. It's an invalid transfer of the property if it's on a septic without a certification that that septic is in good working order within 6 months from the date of close. So I'd want a title company to work with me on that and, work with the seller and figure out, hey, look, we need to get this certificate. Otherwise we can't close. It's those HOA disclosures and information. In fact, our show this morning was all about HOAs and disclosures and stuff.
Right.
Title companies know to get those. And so you definitely want to try to close through escrow. You definitely want to try to get title insurance in place if you can. And that way you can see what's out there. Married couples, we've had those issues where maybe they weren't married when they bought it, but they later became married. Well, there's community property issues there, and you may need both spouses to sign, or at least the spouse not on title to sign a disclaimer or some type of consent to the transaction. So there's a lot of things out there that I think require due diligence and title insurance, and I recommend definitely going through that.
Yeah. All right. If you're just now joining us, this is the Creative Finance Collective. We're talking about creative financing, but we're really here to answer any questions. So it's important if you have questions to make sure to bring them. We'd appreciate it. We do have another question. Are you seeing many commercial subto deals? We've addressed this in the past. We've even had shows about doing subto commercial. But I guess in recent memory or in recent months, are you seeing many? Are you seeing any commercial subto deals?
Not tons.
Hard to
I'm
do.
seeing commercial seller carries, but it's hard to do just because the commercial lending market is so much different than the residential.
Yeah, well, like
yeah.
commercial carry or seller carry in a commercial deal, that's not uncommon at all.
Mm-mm.
I think you could probably, I'm guessing here, but my guess is just in just straight up seller financing, it's way more common in commercial than it is in
Yeah.
residential,
Yeah.
right?
Yeah.
We're talking about subto seller
Yeah.
financing.
Yeah. It's, is it being done? Yes. And have I, this year yet? I don't know that this year I've actively assisted with those. Last year I assisted with a number of subto on commercial or multifamily projects. But the problem is the loans. Three things. First, the loan terms are different and generally shorter. Second is you're dealing with generally a smaller commercial or lender who portfolios their own loans normally, and so they're more inclined to perform audits. And then three, the commercial loan documents generally have a provision in there that states that the lender can declare a default if it appears that an adverse condition has taken place which would jeopardize their security or the ability for them to get paid. And so, and with that, and in conjunction with that, their loan documents generally require that the borrower submit their financials to the lender on an annual basis so that the lender can audit them and make sure that the borrower is still in a good financial condition and not subject to that default provision. And so when they start seeing the updated financials, of the borrower who maybe no longer owns the building, no longer operates whatever's, on there. And they're like, well, where's all your money? It's hard to explain that. And then of course, now the lender's like, well, wait a minute, what's going on here? So, bottom line is it's a little bit more complicated. One of the interesting things about commercial, if it's a single asset entity, you do have a little bit more wiggle room sometimes, depending on the language of the agreements and stuff, to do more creative stuff, such as membership interest transfers and sales and stuff like that, which doesn't change then the borrower-lender relationship or the transfer of the property. You just have to check the language of the loan documents to see if that's, a method that might work.
Right. All right. If you're just now joining us, this is the Creative Finance Collective. Make sure to post your questions in the chat. We'll be here as long as we're getting questions. We have another question, an HOA question. Our show is just about HOA.
Yeah.
If there's a cap on rentals in an HOA and I have a military orders to move, would I be able to be legally exempt?
I don't know. I would recommend talk to your JAG. They will know the answer like that. So, go to the on-base JAG office, your local JAG office, contact them. And I'm pretty confident one of their attorneys will know the answer like that. Won't have to do any research and can tell you exactly what your rights are.
Yeah. And we know enough to know that there are certain rights in play when you've been called to military service. We run into that occasionally in lawsuits and defaults and things like that. If you have reason to know certain things, lawyers have certain obligations or you're given certain rights. But yeah, I'm like you, Sean, I'm not sure about that one. And that would be a good place for them to go, their JAG office. Yeah. So with that, those are all our questions so far. We'll give everybody maybe another minute or so if they've got a question.
Well, I want to bring up something, and I talked about this on the legal update. And so for those watching that didn't watch our show this morning, I'm going to bring it up again because I know, and I see these posts on social media. I see these gurus running around talking about land trusts and how to set them up. And it's not good advice. They're being set up all wrong. And so I'll explain, and maybe people might have questions to follow up on this. But basically, there's two ways to do this. There's a right way and a wrong way to set up a land trust. So the wrong way, which people are telling you to do or telling others to do, is this. You draft the land trust document and you make the seller, the borrower, the grantor of the land trust. They sign the land trust paperwork. You make them the initial beneficiary, and then you make like a third party attorney or private fiduciary, or maybe even the seller, borrower, the trustee. And you then have the seller borrower transfer the property into the trust that's been created once it's all been signed. And then when you close, for you to buy it, for the buyer to acquire the property, instead of doing a deed transfer from there, you basically go and have the seller execute a assignment of beneficial interest of the trust. Maybe they do a resignation as trustee. And basically you put the trust and all powers under the trust into your name as the buyer. And effectively you've conveyed the property without conveying it of public record because it's all behind the scenes. Okay?
Right.
But what nobody's talking about, and it's a real problem, and is this. Now you've basically bound the trust and the property to the debts and obligations of the seller/borrower for their lifetime. And what I mean by that is most states, including Arizona and Wisconsin, where I'm licensed, have statutes that basically say a revocable trust, which is what you would create, a revocable trust and the property in it remains liable for the debts and obligations of its settlor for the settlor's lifetime. And so the question is, well, who's the settlor? Well, if you remember, I used the term making the borrower the seller, the grantor, the creator of the trust, the one that signs the trust,
right,
the one that puts the property into the trust. That is your settlor. It's the person who either creates or funds the trust. They're the settlor. And so in this case, in this situation, it would be the seller / borrower is the seller. So now let's say hypothetically, hey, you come in, you buy it, you do all the transfers, and now you control the trust, and therefore you control the property. Great. 3 months later, the seller / borrower is out driving around. They cause an accident, and God forbid it causes results in someone being seriously injured or dead as a result. Multi-million-dollar claim. Right. Well, guess what? Not only is the seller borrower liable, but so is the land trust and the property in the land trust. If the seller borrower ends up with IRS tax liens, well, so does the land trust and the property in the land trust. If the seller / borrower ends up with the judgment, so does the land trust and the property in the land trust. I can go on and on. It's just a bad situation because now you're risking the survival of the trust and the asset and the property in the trust upon the seller / borrower being a good upstanding citizen, not getting into any accidents, hot water or otherwise for the rest of their life. Bad move. So the proper way to do this is to basically, you create the trust as the buyer, and you are then the grantor. You then fund the trust. So you open a bank account in the name of the trust. You fund the trust. You put $100 into the bank account. So now you funded the trust, and then you enter into a purchase contract. You enter into a purchase contract with your trust, your land trust, which could be titled in the same address as the property. Like that's the title, like 1582, Mulberry Street. That's the trust. You make that the name. And then you make that the buyer under the purchase contract. The seller is the seller. The borrower is the seller. And you close just regular. And then the seller then conveys the property to the trust. Now that works, if the concern is like, oh, I'm trying to, create some level of due on sale avoidance and whatever. That likely works in most states because it still looks like it's just a transfer to a trust. Right. Except in Arizona, right? I mean, that's why we don't do land trust, because in Arizona, any deed to or from a trust, you have to list the name of the, beneficiary and the address. Well, properly, on a trust like that, if you as the buyer create it, you would make your, LLC presumably as the beneficiary of the trust. And therefore it's going to list an LLC and the address as the beneficiary, because you don't want to make the seller the borrower the beneficiary, because you don't want to create that, liability exposure potentially. So I say all that to say, sometimes just because somebody's running around saying things and that they know how to do this and it's this amazing thing and whatever, they're not sharing with you all the potential risks and hazards and consequences. I would much rather risk a due on sale than have my property leaned up because of the seller borrower getting into, hot water. I think the risks are actually better that the lender doesn't call the due on sale than a distressed homeowner, not having any financial issues at any future given time. Right.
Yeah. Well, that's what I was just thinking. If you weighed those risks on the scale, right? The due on sale clause versus the if you were to just weigh it just against the chance of the seller getting into a car accident, right? That statistically speaking, the likelihood of a bad car accident is probably a lot higher than the due on sale clause, if I had to guess. So yeah, so what are you trying to really balance that, I guess? And if you were really thinking about it and trying to protect yourself, then you'd want to make sure that they have, you'd want to know that they were properly insured, to cover those kind of risks. But good insurance would only cover like personal injury risk, right? Not all types of liabilities.
Right. No, credit card debt. It's not going to cover that. It's not going to
Yeah,
cover an IRS lien.
IRS. Yeah, there's like no insurance is going to cover that kind of thing. You'd be
Right.
Yeah,
Yeah.
that's a major problem.
Yes.
All because you're basically trying to hide the transaction. You're not they're doing
Right.
that because they don't want to show a purchase at all with a purchase agreement,
Correct.
right?
Yes.
Or that to be a matter of public record.
Well, yeah, not to be a matter of public record. Yeah, that's what they're trying to do. But I think it's creating, greater liability risk. And I think you can accomplish the same thing. And there's other things, and I haven't really discussed them here, but there's other ways to set that up to, in fact, I'm going to throw this out there because I'm not going to do it today. There's a way to use a land trust to create full anonymity. And I'll tell you what I'm talking about here. So we only do wraps. Alan Sesker only does wraps for subject to, right? Which means that, let's say that I've formed a Wyoming LLC because it's, ultimately anonymous, right?
Right.
So I enter into a contract with the seller. The seller conveys the property to me. The seller signs the warranty deed. So we're clean there, right? Because it says, okay, from seller is grantor to my Wyoming LLC is grantee, and I don't have to then sign anything. But what I do sign, because we do wraps, is I sign the deed of trust, because at the end of the day, an LLC ultimately has to get back to somebody. Somebody has to sign for the company, right?
Right.
And so if you search the public records, you're going to see the warranty deed to my Wyoming LLC, and then you're going to see my deed of trust where I'm the trustor giving the seller a deed of trust against the property to secure my performance of paying their loan for them. And so then I sign it as probably authorized representative of the LLC. Well, my name's going to be on there, right? And if you look at the county recorder's office, you're going to find that. Right. Well, I have a way to use a land trust so that that's all hidden from public record, completely anonymous. And you still can use your Wyoming LLC in conjunction with the land trust. And I'll share it at the interim legal update next Tuesday. So be there, and I'll tell you how to do it so your name never shows up anywhere, and you do the same thing with the wrap.
All right, there's the pre-sale.
Yeah.
You're gonna go through that this next Tuesday?
This next Tuesday.
All right. Well, you
10 a.m. Arizona time.
Yeah. All right. That'll be good. We'll hold you to it. So your land trust did elicit a question from a Facebook user in a comment. So I create the trust as me, the buyer, as the grantor, and then the seller puts property in the trust ? Correct. Followed up by the statement, I've been doing land trusts all wrong. Did they get your clarification correct?
Yes, they got it correct. So you create it. Tune in next week. I'm going to talk to you about some anonymity and how to set this up so that you have complete anonymity on this whole deal. In Arizona, you still are going to have to disclose your Wyoming LLC, but nevertheless, it's pretty cool. All you would see is your land trust and the Wyoming LLC, and you wouldn't know who's really behind any of it. And I'll share how to do that next week on the interim podcast, because that's going to be my legal update. I've already announced it on the show, so I'm not going to do it here. But yeah, so what you do is you create the land trust, you fund the land trust, and then you buy the property in the name of the land trust, and the land trust is the buyer under the purchase contract.
All right. You've started something here. Another question. If I put property from a Facebook user, if I put property in a land trust and I'd like to owner finance to a buyer, do I sell the beneficial interest on an installment sale, or do I create a land contract?
If you want to keep it in the land trust, because your whole point is, a certain level of anonymity and stuff, you can sell the beneficial interest under that land trust. However, since you are the grantor, just know that your LLC, and hopefully you're using a single purpose LLC for this stuff. So, but technically, I mean, here's the problem. If you do this and you sell the beneficial interest to the end buyer, and the LLC that you list as the original, beneficiary grantor of the trust, if they go and end up, you end up with judgments against your LLC, or tax liens or whatever else, against your LLC because you don't pay your IRS taxes, it's going to attach to the trust and to the property, even if you've conveyed your beneficial interest. So you're still tied to that trust. So the grantor never is not tied to that trust. I mean, that's just because the whole idea of the law, right, is that, Andy, if you and I have a bunch of creditors, we can't go and just form a revocable trust,
right,
put our kids as beneficiaries, our spouses beneficiaries, convey all of our assets in there and be like, ha, 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 creditor, you don't get to come after it. Oh, by the way, I can act like an idiot and end up with all this other debt, and you don't get to come after my assets because I put it in this trust that ultimately is revocable, so I can change and modify and whatever, but good luck for you. No, the law's not going to allow for that. And that's why we have these statutes. And so, that's the protection that they're seeking to have. So the grantor is always tied to that trust. That's what you have to understand. The grantor is always tied. And it doesn't matter that you've changed trustees, you change beneficiaries. It's the grantor's on the hook, or the trust is always on the hook for the grantor's ongoing debts and liabilities.
Yeah.
Now, you can sell the property on an installment or land contract, but that's going to show that the land trust conveyed it to a third party, and it's going to be a document of record. So title is still in the name of the land trust, but all other ownership is put into, the third party purchaser's name. So if your whole purpose was, anonymity and due on sale avoidance, well, then now you've basically listed everything out there.
Right. Good stuff. If you're just now joining us, this is the Creative Finance Collective. We're talking about all things creative finance related. More specifically, we've been talking about land trust, which Sean has said we're going to get into. It's going to get into a little bit more this coming Tuesday, so you want to join us for that. If you have any questions, go ahead and post them. We've kind of reached the end of our questions so far. So if you have one, post it and we'll get to it. Otherwise, we're going to pack up the ship and head home, as they say. But I think that's a good question. It's obviously an important one. I find, not to belabor the point, but there seems to be more confusion around trusts than any other formation technique. And whether you're talking about it from an estate planning perspective or setting up a subto deal, boy, the first big mistake everybody seems to have, I can't tell you how many folks come in and want to do a trust because they say, quote, it protects me from liability, so I need to set up a trust. And I'm like, no, you're talking about an LLC or some other corporate thing, but that is not at all what a trust does. And for whatever reason, everybody seems to think that a trust is some sort of liability shield.
Right. So there are things called credit shelter trusts, but they're irrevocable trusts.
Yeah, and they're pretty rare, right? They're not your common trust.
They're not your common trust. They're irrevocable trusts. They're, very expensive to set up. Like, you don't set them up for a few grand. I mean, they're, tens of thousands of dollars to set up a, maybe not tens, but, anywhere from 5 to 10 grand to set up. And it has to have an EIN. It has to file tax returns, the whole thing, which is the same thing an LLC does. So, trusts generally aren't used as asset protection vehicles, although they can, but those are irrevocable trusts, which basically operate very similar as LLCs, although there are certain things like charitable and other types of trusts that can be created that, once again, cost a lot of money to form. And you have really high-end estate planning attorneys that do these, but that aren't cheap. But if you just want, hey, I just want a land trust. Well, that's a revocable trust. That's a common law revocable trust that is the same as your family trust. It's not an asset protection vehicle. It could provide, as I'll share, coming up next week, it can provide anonymity, complete anonymity if you do it right. But it is still, at the end of the day, revocable and can be pierced by creditors of the grantor of that trust.
Yeah, good stuff. All right, Sean, that's all the questions we have.
All right. Well, I think we're good then.
Yeah, let's pack it up, and we'll plan on getting more information on Tuesday about how to keep total anonymity.
Oh man, I'm excited to provide it, and I'll then follow up and discuss it on the Creative Finance Collective here as well.
All right, man. Yeah, all right, everybody.
Cool.
Thanks for joining us. Thanks for the questions. We'll plan on seeing you next time.
All right.
All right.
Have a good night, everyone.